In the year 2000, the Copyright Act was amended. This was done to keep Australian copyright law in touch with the rapid developments in communications technology. In particular, the huge expansion of the Internet. Sections 39B and 112E are part of those amendments. These sections mirror each other, with Section 39B applying to copyright in works and Section 112E to copyright in subject matter other than works. These sections were inserted to provide carriers and carriage service providers, including ISPs, with reasonable certainty about their liability for infringements of copyright that occur on their facilities or infrastructure. The sections state that a service provider is not taken to have authorised copyright infringement merely because another person uses the facilities of the service provider to infringe copyright. These provisions were tested in the 2012 case of Roadshow Films and iiNet. Roadshow claimed that iiNet authorised their clients to infringe Roadshow's rights by failing to prevent users from downloading Roadshow's film using BitTorrent. The case hinged on the interpretation of authorisation and whether by their inaction, iiNet authorised their clients' infringement of Roadshow's rights. Much of the discussion in the case is centred around sections 36(1)A and 101(1)A, which are also part of the 2000 amendments. These sections provide 3 tests designed to be applied to the circumstances of each case to test whether a service provider has authorised an infringement by its customers. These tests are: the extent, if any, of the ISP's power to prevent the doing of the act concerned, the nature of any relationship existing between the ISP and the person who did the act concerned, and whether the ISP took reasonable steps to prevent or avoid the doing of the act, including whether the person complied with any relevant industry codes of practice. You can see that these tests hinge on the action or inaction of the ISP to prove authorisation. Roadshow argued that iiNet's inaction, when told about their client's infringement, amounted to countenancing the acts of infringement. The High Court, however, made it clear that the tests in 101(1)A, when construed with 112E and another section, 22(6), made it clear that iiNet's inactivity was not enough to make them a secondary infringer. As to the first test, the Court found that generally iiNet had limited power to control the activities of their clients, as they had no control over BitTorrent or the availability of copyright content. The Court also found that their customers could simply leave iiNet and sign with another ISP to continue their infringing activities. As to the second test, the relationship between iiNet and their customers was contractual. And while under this contract, iiNet may be able to indirectly prevent the infringements by terminating accounts, they potentially put themselves at risk by wrongfully terminating customers' accounts based on information that may prove incorrect. As to the third test, it was found that due to the limited control iiNet had over their customers and the risk they faced by terminating accounts, their inaction was not unreasonable. Given the requirements outlined in tests which must be met to prove authorisation, the Court confirmed that the mere provision of an Internet service could never be authorisation. Therefore, the courts found that sections 39B and 112E appeared to provide protection where none was required.